Hello, welcome to a new session. Proposal. In this video we going to learn Indian
Section
Contract
2,
Act
A.
from business law and
One
ethics.
person's
willingness to do or abstain from doing anything with a view to obtaining the assent of other person making the proposal or offer is called the proposer or offerer. The person to whom the proposal is made is called the offeree. Next. Section 9 indicates how to make an offer. Or mode of making offer. Express offer. It means an offer made by words spoken or written. Implied offer. It means an offer inferred by the conduct of a person, or by the circumstances of the case. Next. To whom an offer is made. Specific offer. It means an offer made to a particular person, or to a particular group of persons. General offer. It means an offer which is made to the public in general. Next. Legal rules as to valid offer. Offer must be communicated. Case study. Bolton vs. Jones. J offered to purchase 50 feet of leather from Z. Z in the meantime sold his business to B. Therefore, instead of Z, B supplied the leather to J. J refused to accept the leather. It was held that the offer was not communicated to B, and so B had no legal right to accept the offer made by J. Therefore, no contract had concluded between J and B. Case study 2. Carlyle vs. Carbolic Smoke Ball Company. A pharmaceutical company advertised that it would give £100 to anyone who contracted influenza after using their smoke balls for a certain period. Mrs. Carlyle purchased smoke balls and used them as directed. Shortly afterwards, she contracted influenza. She claimed the £100. The court held that the advertisement issued by the pharmaceutical company was a general offer made to the public at large. Mrs. Carlyle, being a member of the public, had received the offer and had acted upon it by using the smoke balls as directed. Therefore, a contract was formed between the pharmaceutical company and Mrs. Carlyle, and so Mrs. Carlyle could claim £100. Case study 3. Lalman Shukla v Gauri Dutt. G's nephew was missing. L, who was Munam of G, went in search of the missing boy. Meanwhile G issued handbills offering reward of Rs 501 to anyone who would trace the boy. L found the boy and brought him home. Since L had no knowledge of the offer made by G, he could not accept such offer. Since there was no acceptance, there could be no contract, and therefore it was held that L was not eligible to receive the reward. Next is communication of complete offer. Henderson vs. Stevenson. X purchased a steamer ticket for traveling from Dublin to Whitehaven. On the back of the ticket, certain conditions were printed. One of the conditions excluded the liability of the company for any loss, injury, or delay to the passengers or their luggage. X never looked at the back of the ticket and there was nothing to draw his attention to the conditions printed on the back side. X's luggage was lost due to the negligence of the servants of the shipping company. Since the steamer company had not taken any steps to ensure that the conditions printed on the back of the ticket were brought to the knowledge of the passengers, such conditions do not form part of the contract. Therefore, X was entitled to recover the damages for loss of his luggage. Parker vs. SE. Rail Company. P deposited his bags in the cloakroom at a railway station. On the face of the receipt, the words "See back" were printed. One of the conditions printed on the back was the liability of the railway company shall be limited to $10 for any package. P.S. bag was lost. He claimed the actual value of bag amounting to $24. It was held that the disclaimer clause was binding on P since the railway company had taken all reasonable steps to ensure that the conditions printed on the back were brought to the knowledge of P. Next is an offer must not thrust the burden of acceptance on the transferee. An offer must not contain any term the non-compliance of which amounts to acceptance. Feldhaus vs. Bindley. A wrote to B, I will sell you my horse for Rs 500. If I do not receive a reply by Sunday next, I shall assume that you have accepted the offer. B did not reply. It was held that an offer cannot impose the burden on the offeree to reply. Acceptance is valid only if it is communicated to the offerer. Since B had not communicated his acceptance to A, there was no contract between A and B, and therefore A could not sue B. Next is cross offers do not conclude a contract. Two offers which are similar in all respects made by two parties to each other, in ignorance of each other's offer, are known as cross offers. Cross offers do not conclude a contract. Counter offer. A counter offer amounts to rejection of the original offer. Next is offer must be distinguished from invitation to offer. An invitation to offer does not imply a valid offer. Next is offer must be distinguished from a declaration of intention. A declaration or a statement merely indicates that an offer will be made or invited in future. Lastly, an offer must be certain. The terms of the offer must be definite, unambiguous, and certain. Next topic is lapse of an offer. Notice by offerer, that is, revocation. Revocation of offer means withdrawal or cancellation of the offer. An offer can be revoked by the offerer anytime. However, revocation is effective only if it is made before the offer is accepted. Next, lapse of time. An offer lapses if it is not accepted within the time specified in the offer. Within reasonable time, if no time is specified in the offer. Next, non-fulfillment of condition precedent. If an offer requires fulfillment of some condition before the offer can be accepted, the offer shall lapse if such condition is not fulfilled. Next, counter offer. A counter offer results in rejection of the original offer. Next, acceptance is not made in prescribed mode. If the offeree accepts the offer in a manner which is different from the manner specified by the offerer, the offerer may refuse to treat such acceptance as valid, and consequently the offer shall lapse. Next, death or insanity of the offerer or offeree. An offer shall lapse in the following cases: where the offerer dies or becomes insolvent and such fact comes to the knowledge of the offeree before acceptance of the offer. Where the offeree dies or becomes insolvent before acceptance of the offer. Next, rejection by the offeree. An offer comes to an end if the offeree rejects the offer and communicates his refusal to the offerer. Lastly, subsequent illegality. If, after making of an offer, the subject matter of the offer is destroyed or the performance becomes impossible or unlawful, the offer shall lapse. Next topic is standing offers. It is also known as open offer or continuous offer. Here a person offers to another specific goods up to a stated/required quantity at a certain rate during a fixed period. An acceptance of such an offer merely amounts to intimation it will be accepted from time to time by placing order. Next topic is revocation of offer by the offerer. At any time before acceptance, revocation must be communicated to the offeree. If before its actual communication it is accepted, it will create binding contract. The revocation must reach the offeree before he sends out the acceptance. Next topic: acceptance. Section 2, B. Definition of acceptance. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Promise. In case of a specific offer, only that particular person or group of persons to whom the specific offer has been made and none else. In case of a general offer, any person if he has the knowledge of the offer, and he fulfills the terms and conditions of the offer. Mode of acceptance: express acceptance, implied acceptance. Section 7 Legal rules for a valid acceptance. Absolute and unqualified. The offeree should assent to all the terms of the offer. There must be no variation, reservation, that is, acceptance must be unconditional. Next, acceptance must be communicated. Acceptance cannot be made in ignorance of the offer. Mere mental acceptance is no acceptance. Next. Acceptance to whom? The acceptance must be communicated to the offerer. Feldhaus vs. Bindley. F made an offer to his nephew to buy the nephew's horse for Rs 500. The offer stated that if the nephew failed to reply to the offer of F within 10 days, F shall consider that the horse had been sold to him. The nephew directed his manager not to sell that horse to anybody since he wanted to sell that horse to F. But the nephew did not send any reply to F. By mistake, the manager sold that horse to some other person. It was held that nephew was not bound to send notice of refusal to F. Therefore, failure to send the letter of refusal within 10 days did not amount to acceptance. Also, nephew's communication of decision to sell the horse of F did not result in a valid acceptance since such decision was not communicated to F, the offerer. Since there was no contract between F and the nephew, F had no right against the nephew. Next topic is classification of offer. Express offer. By words or by written. Example. X says to Y, "Will you purchase my white horse for Rs 12,000? Implied offer. Inferred by conduct or circumstances. Example. To board in a metro rail at metro station. General offer. Public at large. Example. An offer to give reward to anybody who finds the lost horse. Case law. Carlo vs. Carbolic Balls Company. Specific offer. Specific or ascertained person or only that person. Example. A offers to sell his car to B. Only B can accept the offer. Counteroffer. Offeree accepts subject to certain conditions or qualification, not accepting, terminating, the original offer. Example. Mr. A offered to sell his car to Mr. B for 20,000. B replied that he can accept for only Rs 17,000. Original offer gets terminated. Cross offer. Identical offer by each party, ignorance of each other, no contract. As nobody shall be called for. Example. Mr. A offers by a letter to sell his car to Mr. B for Rs 0.15,000. Mr. B, at the same time, offers by a letter to buy A's car for Rs 0.15,000. The two letters cross each other in the post. Refer case study Tin vs. Hoffman. Standing or open or continuing offer. Open for acceptance. For reasonable time. Example. Tenders or share applications. Invitation to an offer. General information, public notice, to initiate the offer. Note. Only one party, no question of communication, performance of invitation of offer, no formation of contract. Example. Shopkeeper's catalog of price, display of goods in a shop. Next. Acceptance by whom? Acceptance must be given by the person who has the authority to accept the offer. Next. Manner of acceptance. Situation, A. The offer does not prescribe the manner of acceptance. The offer must be accepted in some usual and reasonable manner. Situation, B. The offer prescribes the manner of acceptance. The offer must be accepted in the prescribed manner. If the offer is not accepted in the prescribed manner, the offerer may approve or reject such acceptance. Next. Time limit for acceptance. Situation, A. The offer does not prescribe the time limit. The offer must be accepted within reasonable time. Situation, B. The offer prescribes the time limit. The offer must be accepted within the prescribed time limit. Next. Acceptance must be given before the offer lapses or revoked. Acceptance can be given only to an existing offer. An offer open for a limited period can be accepted only before the expiry of such specified period. An offer can be revoked before acceptance. Next. Mode of acceptance. Acceptance may be given by performance of conditions, or acceptance of consideration.
Section 4. Communication when complete. Offer. When the offer comes to the knowledge of the offers. Acceptance. 1. Communication is complete against the offer. When acceptance is put in a course of transmission so as to be out of the power of the offeree. 2. Communication is complete against the offeree. When acceptance to the knowledge of the offerer. 3. Revocation. 1. Communication is complete against the person who makes it. When revocation is put in a course of transmission so as to be out of the power of the person who makes it. 2. Communication is complete against the person to whom it is made. When revocation comes to the knowledge of the person to whom it is made. Next. Section 5. Time limit for revocation. 1. Revocation of offer and time limit for revocation before communication of acceptance is complete against the offerer. 2. Revocation of acceptance and time limit for revocation before communication of acceptance is complete against the offeree. Next topic is Section 2, D. Meaning of consideration. When, at the desire of the promisor, the promisee, or any other person has done or abstained from doing, or does/abstains from doing, or promises to do or to abstain from doing, something, such act, or abstinence/promise is called a consideration for the promise. Something in return quid pro quo. The price for which a promise is bought. Sign and symbol of every contract. Exchange of promise or performance with parties. No single promise is enforceable without consideration. Result in a benefit to the promiser or detriment to the promisee or both. Let's see an example. Mr. X agrees to sell his car, consideration for Mr. Y's promise, to Y for Rs. 1, 40,000, consideration for Mr. X's promise. Case law. Misa vs. Curry. A valuable consideration in the sense of law may consist either in some right, interest, profit or benefit accruing to one party, that is promisor, or forbearance, detriment, loss, or responsibility given, suffered or undertaken by the other, that is the promisee. Next topic. Essentials of a valid consideration. 1. Consideration must move at the desire of the promisor. An act or abstinence shall constitute a good consideration only if it is done at the desire of the promisor. 2. Consideration may move from promisee or any other person. So long as there is consideration for promise, it is immaterial as to who has furnished it. If a party receives consideration, the contract is valid, even though the person furnishing the consideration is not a party to the contract. Where a third party furnishes the consideration, it is valid consideration. As long as there is consideration in a contract, it is immaterial as to who has given this consideration. This rule is generally stated as privity of consideration is not required. 3. No adequacy of consideration required. The law requires that there must be consideration in every contract. However, adequacy of consideration is not required. Even if it is proved that such consideration is inadequate, the contract is not void. The fact of inadequacy of consideration shall be given due weightage while determining whether the consent of the promisor was freely given or not. 4. It must be different from promisor's existing obligation. Consideration received by a party must be something more than the other party's contractual and legal obligation. 5. Consideration must be lawful. An agreement is void if the consideration furnished by any of the parties is unlawful. 6. It must be real, and not illusory. Consideration received by a party must be of some value. Consideration must not be illusionary, that is existing in name. Next topic, moving on to Exceptions Section 25. No consideration, no contract. 1. Agreements made on account of natural love and affection. Conditions. The agreement is made in writing. The agreement must be registered. The agreement must be made between the parties standing in immediate relation to each other. There must be natural love and affection between the parties. However, mere nearness of relationship does not imply natural love and affection. Example: Mr. X promised to pay the debts of brother Mr. Y, on account of love and affection. The agreement was put to writing and registered. Valid contract. Refer case study for more details. Case law. Rajuki vs. Bhutnath. 2. Compensation for past voluntary services. Conditions. A party renders some services to the other party or performs the legal obligation of the other party. The services are rendered without any desire of the other party, that is, the services are rendered voluntarily. The other party afterwards promises to compensate the former party for the services rendered to him. Example: Mr. A finds Mr. B's purse and gives it to him. Mr. B promises to give Mr. A 100 Indian rupees. 3. Promise to pay a time-barred debt. A creditor can sue the debtor for recovery of his money by going to the court of law. However, if the creditor fails to institute the suit within 3 years of debt becoming due for payment, the debt is said to be time-barred debt, that is, the creditor cannot institute the suit after the expiry of said period of 3 years. The general rule is that an agreement to pay a time-barred debt is void. Exception. An agreement to pay a time-barred debt is enforceable if the following conditions are satisfied. The debt is a time-barred debt. The debtor promises to pay the time-barred debt. The promise is made in writing. The promise is signed by the debtor. Example: Mr. X owes Mr. Y Indian rupee 1,00,000, but the debt is barred by Limitation Act. Mr. X signs a written promise to pay Mr. Y 95,000 Indian rupees on account of debt. 4. Law of agency between principal and agent. No consideration is necessary to create an agency. Refer case study Dunlop Pneumatic Tire Company Limited vs. Selfridge & Co. Limited. 5. Completed gift. Agreement to make a gift is not enforceable. However, once a gift has actually been made, the donor cannot demand it back on the ground that there was no consideration. Example: donations. 6. Remission. No consideration is necessary for an agreement to receive less than what is due. 7. Guarantee. In a contract of guarantee, consideration received by the principal debtor shall be sufficient consideration for the surety. 8. Contract under seal. Under the law, a contract made in the form of a deed under seal is valid even though it is made without consideration. Example: deed under seal. Next topic is meaning of privity of contract. The general rule is that only the parties to a contract can sue. In other words, if a person is not a party to the contract, that is a stranger to contract, he cannot sue. Privity of consideration. It is well established that privity of consideration is not required. Consideration may move from promisee or any other person. So long as there is consideration for promise, it is immaterial who has furnished it. Example: Dunlop Pneumatic Tire Company vs. Selfridge & Co. D entered into a contract of sale of certain tires to P. The contract provided that P shall not sell the tires below the list price. Also, the contract provided that P shall, at time of resale, impose a condition on the retailer that sale by retailer shall not be made below the list price. P sold certain tires to S resold certain tires below the list price. In a suit instituted by D against S, the court held that such suit was not maintainable since there was no privity of contract between S and D. Privity of contract exceptions. 1. Creation of a trust. Beneficiary is not a party to the agreement creating a trust. However, the beneficiary is allowed to sue the trustee for enforcement of trustee's duties. Refer case study. Dankur vs. Sarla Devi. 2. Marriage or family arrangements. Where a marriage or family settlement is made, the person who is a beneficiary under such settlement is entitled to sue even though he may not be a party to sue settlement. 3. Acknowledgement. The person, who becomes an agent of a third party by acknowledgement, can be sued by such third party. Example: Mr. A pays Mr. B 500 Indian rupees and Mr. B acknowledges to Mr. C that he holds for him. Here Mr. C can enforce. 4. Assignment of a contract. An assignee is entitled to exercise all the rights which could have been exercised by the assignor previously, even though the assignee was not a party to the contract as originally made. Example: Mr. A assigns his insurance policy in favor of his wife. The wife can enforce even though not a party. 5. Covenants running with the land may be enforced by the successor of the seller. Example: Mr. A gifts the property to his son-in-law on his marriage with daughter. Mr. A gets the right to enforce his rights which Mr. A had already.
Section 11. Capacity of parties. Person is competent to contract who is of the age of majority and of sound mind, and not disqualified from contracting by any law to which he is subject. Effects of minor's agreement. 1. Agreement is void ab initio, that is without any legal effect. A minor is incompetent to enter into any contract. Therefore, any agreement made by a minor is void ab initio, i.e., it is without any legal effect. Mohorai Bibi vs. Darmodas goes. A minor entered into an agreement for mortgage of his property. He was paid a certain amount for mortgaging the property. Afterwards, the mortgagee filed a suit against the minor for recovery of money paid to the minor. It was held that the money was paid to the minor under a void agreement, and therefore the mortgage was not valid. 2. An agreement for the benefit of minor is enforceable by minor. The principle laid down in Mohorai Bibi vs. Taramodas goes applies only if the agreement creates an obligation of a minor. Where an agreement is for the benefit of a minor, the agreement is not void and therefore the minor can enforce such agreement. If the other party to the agreement fails to perform his part of obligation, the minor can claim restitution. 3. Restitution. Kongul vs. Laka Singh. Following principles were laid down in the above case. The court may grant relief to the other party if the other party had entered into a contract with the minor on the basis of a misrepresentation made by the minor. If the minor had received some consideration under the agreement, the court may grant restitution to the other party. However, the minor shall not be personally liable. In other words, restitution shall be made only to such an extent as the estate of minor has been benefited. The power of the court to grant relief is discretionary in nature. The court shall not grant relief if the other party had the knowledge of the fact that it was entering into an agreement with a minor. 4. No estoppel against a minor. If the rule of estoppel is applied against a minor, it would amount to an indirect way of enforcing a void agreement. Therefore, the rule of estoppel does not apply against a minor. 5. No specific performance. The other party cannot demand that minor should perform the obligation which he had agreed to perform under the agreement. 6. No ratification by a minor. Ratification means acceptance of a transaction already done. An agreement entered into by a minor cannot be ratified by him after he has attained majority. Where on attaining majority, a minor agrees to pay for the goods supplied by a third party, such agreement is void for want of consideration. 7. No liability of guardian. The guardian of a minor shall not be liable for acts of a minor. 8. Contracts by a guardian. The contract by a guardian on behalf of a minor shall be valid if the contract is for the benefit of minor, and the guardian has the authority to enter into such a contract. 9. Minor's liability for necessities. Nature of liability. As per section 68, a minor is liable for necessities supplied to him, or any other person who is dependent on the minor. Conditions. The liability is only for necessities of life. The term necessity means necessities of life as per the social status and conditions of life of the minor. The minor is not already in possession of such necessities. The minor shall not be personally liable. 10. Position of minor. Minor cannot be a guarantor. Minor may be admitted as a member where the shares are fully paid up. Minor can be an apprentice provided he is of at least 14 years of age. Minor cannot be a partner in a firm. However, he may be admitted to the benefits of partnership. Section 12. Persons of unsound mind. Meaning of sound mind. A person is said to be of sound mind if he is able to understand the contract, and form a rational judgment. Presumption. The law presumes that every person is of sound mind. Requirements of law. At the time of entering into a contract, a person must be of sound mind. A person can enter into a contract in accordance with the following principles. Nature of person of sound mind. He can enter into a contract at all the times. He cannot enter into a contract when he is of unsound mind. Nature of person of unsound mind. He can enter into a contract only at such intervals of time, if any, when he is of sound mind. Burden of proof. A person who is usually of sound mind. The burden of proving that he was of unsound mind at the time of entering into the contract lies on the person who challenges the validity of the contract. A person who is usually of unsound mind. The burden of proving that he was of sound mind at the time of entering into the contract lies on the person who affirms the contract. Next is persons disqualified under law. Company. A company is a legal person and therefore it can enter into a contract in its own name. However, a company is disqualified to enter into any contract which falls outside the object clause of memorandum. Alien enemy. A person not an Indian citizen is an alien. During the peace, alien can enter into contract. But on the declaration of war he becomes an alien enemy. A contract with an alien enemy becomes unenforceable. Foreign diplomats can be sued only in the following cases. Where he submits himself to the court. Where approval of CG is obtained. Convict. Existing contract is suspended until his conviction is completed. Fresh contract cannot be entered into. Permission of CG and existing contract can be enforced. A fresh contract can be entered into.